The Clerk will now proceed to read the orders of the day.
Legal Aid, Sentencing and Punishment of Offenders Bill, second reading.
Before I call Mr. Kenneth Clarke, can I say that this is a well-subscribed second reading. There is an 8-minute limit on backbench contributions. Could I ask both front benches to use their constraint in order that we can get more backbenchers? Oh, I've never said anything so popular in my life. But can I also say, because of the numbers that have subscribed, please do not approach the chair to ask where you are on the list. If you've approached the Speaker or written to the Speaker, you are on the list. Mr. Kenneth Clarke.
Mr. Deputy Speaker, I beg to move that the bill be now read a second time, and I will try to observe your stricture, but it is a very large piece of legislation, but I probably will have to restrict the number of times I give way to interventions. Mr. Speaker, I am determined to reform the justice system in this country, keeping the public safe, ensuring that those who break the law face the consequences, and providing swift, cost-effective access to justice are fundamental responsibilities of the state towards its citizens. Yet the last 13 years of government have left us a system whose cost and scale have exploded and whose failings can no longer be tolerated. In the area of criminal justice, more than 20 new Acts of Parliament, thousands of new criminal offences, and a huge increase in the prison population can't mask very deep flaws in the system. Briefly, our sentencing framework is a mess of Byzantine complexity, which even trained lawyers and judges find confusing, never mind the general public. Our punishments don't work. Community sentences are weak, asking little of offenders. Prisons have become so crowded there is no space for governors to enforce regimes of meaningful work or reparation. Far too many prisoners are left idle in their cells, often on drugs. And for this model, the taxpayer has the privilege of paying out an extraordinary sum, £44,000 per prison place per year. I've just been assured that the Ritz is even more expensive, so I slightly exaggerated, but £44,000 per prison place per year is enough to pay the salary of 2 newly qualified nurses or teachers. I give way to my predecessor, the member for Blackburn.
To the right honourable gentleman, the Lord Chancellor, Mr. Deputy Speaker. We've heard this alleged litany of failures. When the right honourable gentleman was Home Secretary, crime was at a post-war peak on both the measures that the Prime Minister used to discuss crime at questions earlier today. Since then, burglaries have dropped by 70%, thefts by 50%, crime overall by 50%. It's the fact that he never ever refers to the outcomes of our record, the fact that this mainly happened under us, or that this process started under his successor, Michael Howard.
First, the idea that I set off a crime wave when I was Home Secretary is, I think, a charge I'll answer on some other occasion, frankly. So far as the decline in crime is concerned, the biggest decline in crime has been in theft, because car manufacturers made the cars more secure, so the courts that used to be full of taking and driving away offences are no longer full of those offences, yet it's more difficult to take the cars. The fall in burglary coincided with an economic boom, one of the consequences that came from it. And the 20-plus bills that he and his predecessors brought before this House, more than one criminal justice bill a year, the countless changes in sentences filled up the prisons, but in my opinion had no provable, demonstrable effect on the levels of crime in this country at all. Now, he's ex-front bench. I think I'll give way to him later, but I should observe the structures of the Deputy Speaker. Otherwise, I do enjoy debating with the honourable gentleman, but I think I should move on a little further into my speech. And as he's heard me say before, the reoffending rates are a national scandal. That's why the system is failing. Half of offenders, 49%, have been reconvicted, in part because the system isn't tackling the underlying causes of their criminality, like drug abuse, poor mental health and inadequate skills. So the consequence of that failure is new victims of crime every day. Despite improvement, victims and witnesses still get treated too often like an afterthought, not a central concern of justice. That's why we need intelligent, radical reform of the criminal justice system to protect and serve the needs of law-abiding members of society. What then about the framework of civil justice, which I would later, but let me just deal with what we're having to tackle in civil justice. Sad truth is that it too has serious weaknesses. Courts should be accessible, efficient, but generally turned to as a place of last resort, not a first choice. But actually we have a litigious society. Far too many cases go down the court route unnecessarily. More than 3/4 of claims in the civil system last year set down to proceed to trial were settled before it took place. Many of those cases might have been resolved earlier with different approaches aimed at simpler dispute resolution. Ordinary citizens find the law an expensive, daunting nightmare, not a public service. Well, in a second. Courts are slow, burdened by high costs, bureaucratic processes and procedures. For example, the average public family law case length in 1989 was 12 weeks. By 2010, it stood at 53 weeks, similar cases taking 4 times as long as they used to do. I'll give way to the member for Nottingham East.
I'm grateful to the Lord Chancellor. On the question about victims, I think many victims of crime will be shocked with his proposals to limit the freedom of judges to put a defendant in remand, remanded them in custody. Why is he limiting and fettering the ability of judges to put those defendants on remand?
I'm going to argue it later. I'll try to avoid repeating, but I can't understand why people are so incensed that people who aren't going to be sent to prison are kept in prison awaiting the trial. Every year we have 16,000 people who have refused bail, are kept in prison, they come up and are convicted, and they're immediately given bail. And it's a quarter of all the people kept in custody who are released when they come up for trial. And I'll come back to it in a second and try to avoid repeating the same arguments. But unless one is trying to fill up the prisons with people, it does seem to me one of the more obvious steps we can take. They're not going to justify punishment by imprisonment when they get there. It seems to me pointless to refuse them bail, except in the case of domestic violence cases, where we have agreed to make an exception, because obviously you can't give bail to someone who's going back to live with the person who is the alleged victim of the domestic violence. So I give way to my honourable friend, then move on.
The Minister will be aware that many people who are remanded on bail are remanded on bail because they refuse to turn up to court, causing the public all sorts of expense by the taxpayer. Can he assure us that even if the crime committed is not one that would normally result in a jail sentence, that people who consistently refuse to turn up at court will be remanded in custody?
Without fettering judicial discretion, I think I can give that assurance. There are all kinds of grounds on which you can refuse bail. What we're just saying is that where it is likely that the person isn't going to be imprisoned anyway when they come up for trial, you shouldn't refuse them bail in such circumstances. I'll move on again, but I was on the civil justice system. No, I'm sorry, I must move on again. I respect the right honourable gentleman. I've just said how ordinary citizens find the civil law a rather nightmare experience when they resort to it. But thanks to the present scope of legal aid and the way in which the no-win, no-fee system operates, many people, and many small businesses in particular, live in fear of legal action. Now, I accept that access to justice for the protection of fundamental rights is vitally important for a democratic society, something I will not compromise upon. However, our current legal aid system can encourage people to bring their problems before the courts when their basic problem isn't a legal one and the problem will be better dealt with in other ways. The scope of legal aid in this country has expanded too far. It can't be right, for example, the taxpayer is forced to pay for legal advice to foreign students whose visa applications are turned down, and there are many other examples. And our legal aid system also faces a completely unignorable problem of affordability. I've listened to arguments in the media today challenging this, but we have by far the most expensive system in the world. After Northern Ireland, where I'm sure they're going to tackle the same problem, it costs £39 per head of population in this country each year, compared with £8 in, for example, New Zealand, which is a directly similar system of law. And in any circumstances, it would need reform. In the country's current financial crisis, reform is imperative. Now, if I may say so to the bench opposite, I don't normally give gratuitous advice, but I think the Labour Party are facing one of the problems that we found we faced in 1997. Having the courage to admit that they made some mistakes and they left some things in a mess. Now, I thought it had been acknowledged by my opposite number on Labour's watch, and I quote, "Talking tough in order not to look soft made it harder to focus on what was effective." Wise words. I thought when we set off on this process of consultation, I had the widespread support of many opposite. I ask him to reflect on the way in which he started his consideration before he gets on with the rest of the debate. But in fact, when in office, in our prisons and in our courts, Labour's strategy was legislative incontinence combined with knee-jerk populism. And in prisons, they made the mistake of being unable to make proper provision for the demand for places that they stimulated. Overcrowding devoured the very budgets that should have been used productively to cut reoffending and improve public safety in a lasting way. And what was the final result? We all remember. They had to reduce the release point from 2/3 to halfway through the sentence. Then they had to resort to the financial chicanery of keeping the cost of building prisons off the balance sheet, the so-called Carter prisons. Finally, the ultimate absurdity. They had to let out 80,000 prisoners early before the end of their sentence in order to offset the cost of the allegedly tougher sentences that they had imposed. That's why we need reform now to reverse that nonsense. On wider justice matters, they proved little better at getting a grip. They had 30 consultations on legal aid since 2006. They didn't act decisively, put it on a sustainable footing, or to address the litigiousness to which excessively wide available funding contributed.
Friend, and he has had a consultation to which I hope he's listened, in particular in respect of clinical negligence affecting children with multiple injuries that may have arisen from birth. It's not clear to me yet that the government has found a way of ensuring that this very deserving and quite small group of people will have the access to justice and to the settlements which they need.
Yeah. Well, firstly, the clinical negligence we have addressed, and we actually think it's a very large part of it is done on a no-win, no-fee basis now. That is the way we should proceed. Clinical negligence, particularly cases of the kind that the Right Honourable Member refers to, are particularly expensive, and it is quite difficult to decide whether to proceed with them. So we are making special arrangements, particularly for the expensive medical reports that have to be obtained before a case can properly be decided upon, and we are making arrangements to make the insurance reimbursable in those cases. I actually would also like to see a system developed by the NHS Litigation Authority and by the best of the practitioners to exchange these expert medical reports at a very early stage, so that unnecessary litigation about whether a tragic disaster to a newborn baby is actually a kind of natural tragedy or actually a result of negligence needn't be dragged on through the many years it can take through the court. So I accept the special case. It's one of the things we did consider carefully on the consultation. We've made quite a lot of changes in the consultation, of which some were referred to dramatically in outside comment, but it's the way in which we consulted. I'll take these last two, then I really will get on for a bit.
I'm very grateful to the Secretary of State for giving way. I hear what he's saying about the failure of the last government to tackle the burgeoning legal aid system, but isn't something else they failed to tackle? The complexity of some of the other departmental work that our Citizens Advice Bureau, who do such valuable work, help with. For example, DWP forms. And in the government's response, it hints at there being a review of some of the other parts of legal aid, which inevitably are going to have to be cut. Can the Secretary of State give more detail at some point about that review of legal aid and the fact the burden might be shared across government departments?
I'm trying to avoid dotting about my subject, partly because it is such an enormous bill. I promised my honourable friend that I will return to the whole question of alternative forms of advice and CAB and make an announcement at a later stage in the bill.
grateful to the Lord Chancellor for giving way. Can I raise another particular aspect of the changes to legal aid, and that's the removal of legal aid to women applying for indefinite leave to remain under the domestic violence rule. In an answer to a parliamentary question, the Immigration Minister reported that only 710 women were granted this in 2009. So we're not talking about a considerable number of women here, but they are very vulnerable individuals. Will he think again on this particular aspect of his proposals?
I think we have actually responded to that to some extent, and I think what I'd better do is say that my honourable friend, the member for Huntingdon, will be winding up this debate on the end of second reading, and he will have time to consider a detailed. Well, and so will they. The two ministers on the bench know we have talked about this, we have considered it carefully, and I leave it to my honourable friend to give you the authoritative reply in the round-up when it comes. Now, turning to the bill, as I hope I've already indicated, the mess we've inherited requires a bold, sustained, principled effort, not salami slicing and half measures. So the bill I'm bringing forward today is one part of that balanced package of reform which is needed. Now, Mr. Speaker, unusually, I made a full statement to the House last week on the subject, which was debated then for 1.5 hours, so I don't propose to repeat in depth what I said then. But let me begin with the inevitable controversy which any measures on criminal sentencing are bound to provoke. And I have to say, it seems to me it's a kind of natural part of contemporary political debate to simplify the subject to whatever is under debate and to make extremes out of it all. And I resign to fate that on law and order issues, above all, there's a tendency to polarise and frame reforms as either dry and tough or wet, soft and liberal. The truth is actually somewhat in between. And my aim in the measures that I am bringing forward was to consult on a balanced package, and I can tell the House it will remain so. What the measures do is address the weaknesses that I've described we have inherited. Now, for serious crime, the public needs to have confidence in a system of effective punishment and just retribution. So my reforms include, for example, introducing a 40-hour working week across the prison estate to introduce productive, hard work into prisons in place of enforced idleness. In the bill, toughening up community sentences by allowing courts to curfew offenders for longer, 16 hours a day for up to 12 months, as well as banning them from going abroad. As I signalled last week, we intend to bring forward measures to clarify householders' rights of defence and to consult on criminalising squatting. The bill creates a new offence of possessing a knife to threaten or endanger a person with a prison sentence of at least 6 months for over 18s, to send a clear message to those who possess a knife to threaten others. In addition, we are conducting a review with the intention of replacing the totally discredited sentence of locking people up for an undetermined and indefinite time, the so-called imprisonment for public protection, with a tough, determinate sentencing regime. I also propose to deliver a system that offers better reparation to victims. The bill will replace and augment the Prisoners' Earnings Act, which was never implemented by the previous government. It was a Conservative measure, which we will implement this autumn till we've replaced and augmented it. This will allow us to deduct wages from prisoners, so that instead of just being a drain on the system, we can deduct from those wages money to help pay for services for victims of crime. The bill also puts a positive obligation on courts to make offenders pay compensation direct to victims. Give way to the Honourable.
I'm very grateful to the Lord Chancellor for giving away. He mentioned the review of indeterminate sentences before, and I'm very concerned that he's going to come to the wrong conclusion here. And could I ask him, when he conducts his review, to look at the experience in Northern Ireland, where extended and indeterminate sentences have been available since 2008, but where, crucially, the assessment of dangerousness is left in the hands of the judges. It's a smaller system, but in the 3 years since, there have been 63 extended sentences and 7 indeterminate sentences only. It seems they've managed to combine public safety with manageable numbers. Will you look at that experience?
Well, we are having a review, so I will look at that. But upon consultation, the reason I've come to the conclusion that I have is that this was legislated for in 2003, the idea that a few hundred people might be affected. It was introduced in 2005. The last government, of which he was a member, was already trying to reform it because it was out of control in 2008, and it hasn't worked. I proposed further reforms in the Green Paper, and the response I got to the consultation was a very large number of people in the criminal justice system saying it should be totally repealed. I quoted David Thomas QC, the author of Thomas on Sentencing last week, who described the whole thing as an unmitigated disaster. Now we are carrying out a review. We're determined to replace it. I will have a look at what the Right Honourable Gentleman refers me to see if there's some system of some kind in Northern Ireland that might be appropriate. Now, after punishment and reparation comes rehabilitation to reduce reoffending, and this really is at the core of our process of reform. Sentences need to be both punitive and reformative, and the bill will help ensure that more offenders with drugs, alcohol or mental health problems are addressed and receive treatment at the earliest opportunity. And this complements our efforts to address another scandal, may do both, but complements, I hope, that drugs are widely available in prisons, and we're beginning by introducing drug-free wings. Of course, my single most radical proposal on rehabilitation is a non-legislative change to introduce a fundamental shift in how we approach the issue by paying by results to unlock private capital, benefit from the innovation of the voluntary sector and get the whole system pulling in the same direction. We will pay providers a return on their ethical investment for what works in the public interest. Turning criminals into ex-criminals should be an object of the system, certainly.
Secretary of State for giving way, and I'm interested in what he was saying about the number of people who unfortunately in our prisons suffer from mental illness and need support and treatment whilst in prison, which is often inadequate. Does he also recognise there is a greater problem that many people who need support for mental illness and mental health crises don't get it, as insufficient resources and as insufficient understanding by the police and others that when there are minor offences committed, the real cause is actually mental illness, not anything else, and we need a more sympathetic approach and supportive and therapeutic approach to dealing with these poor, unfortunate people?
My right honourable friend, the Secretary of State for Health, agrees with the honourable gentleman and I, that is indeed the case. I've been having discussions with the Secretary for Health, my ministerial team and his ministerial team have. He has a strategy for trying to improve mental health services to the population as a whole. As part of that, we're addressing what can be done with the mentally ill who find themselves in prison. Some should just be diverted out of the criminal justice system altogether. Some can be better treated in secure accommodation in the National Health Service. Certainly, many can be treated better than is at the moment the case when being incarcerated in prison is not suitable. It's an important matter. I can assure the honourable gentleman that my right honourable friend and I both share his concern. So, underpinning punishment, reparation and rehabilitation is what might be called system reform, simplification, restoration of discretion to judges and the relief of unnecessary pressures of the system. At the same time, we must take a much more robust approach to costs in the system, including that of prison. We've already shown that by competing prisons, it's possible to get costs down while improving service quality. But key measures in the bill include reforming the use of remand. I've just dealt with this a moment ago. I've already told the House that reoffending is the central idea of my reforms. One of the main barriers to doing things over the last few years is that the prisons have been clogged up, sometimes with people who don't need to be there at all. And I won't repeat the arguments that I gave a moment ago, which give rise to the part of the bill which restricts the power of courts to remand those who have no reasonable prospect of receiving a custodial sentence, with the exception I've already described in cases of domestic violence.
I'm very grateful. In answer to his honourable friend, the member for Monmouth, he said that where a defendant failed to come back to court on time, the court would still be able to remand him in custody so that he could get to court. The Secretary of State spoke clearly in error. If he refers to page 166 of his own bill, he will see that paragraph 5 of Schedule 10 makes absolutely clear that even where a defendant has failed to surrender to bail and is arrested, He cannot be detained in custody to appear in court unless there is a real prospect of his subsequent sentence to imprisonment. How is the public going to be made safer by that, or witnesses protected?
Well, I will address the extent to which we restrain the ordinary discretion as determined under the Bail Acts, for which people grant and refuse bail. But I repeat the point I made a moment ago. In 2010, we had over 16,000 people remanded in custody who were released when they came up for trial and were either pleaded guilty or were convicted. And carrying on with a system whereby people who refuse bail, when everybody knows they won't be imprisoned if convicted, is simply a very wasteful use of a very expensive place in our prison system.
The Right Honourable Member, would the Lord Chancellor help us in this respect? If you breach your bail, you have committed a criminal offence. And if you breached your bail, which is, as I say, a criminal offence, you can therefore, and usually do, receive a custodial sentence, especially if you breached your bail by not coming to court when you should have come to court.
I'm grateful. My honourable friend has been in practice much more recently than either the member for Blackburn or myself. We will no doubt continue to study this after the debate has concluded. Overall, the sentencing reforms are balanced, and if I again may quote the words of my opposition shadow, the Honourable Member for Tooting, he described them, when I first put them out in the Green Paper, as a perfectly sensible vision for a sentencing policy, and they will, in my view, achieve a very significant transformation. Now, this brings me to the rest of the bill, covering legal aid and provision on litigation and funding. No government looks to tackle legal aid lightly, but the system as it stands is obviously unaffordable. Where Labour had 30 goes at fixing it from 2006 to the end of their period of office, we've sought to go back and think about what the taxpayer should pay for by way of litigation from first principles. Our priority, Mr. Deputy Speaker, is cases where people's life or liberty is at stake, where they're at risk of serious physical harm or immediate loss of their home, or where their children may be taken into care. After our reforms, legal aid will routinely be available in 25 areas, including for criminal cases, for most judicial review proceedings, for private family law cases involving domestic violence, child abuse and child abduction, for community care, for debt where the home is at immediate risk, for mental health cases, and for cases concerning special educational needs, among others. And we modified our original proposals in response to consultation, listening carefully to the thousands of responses that we had. Just finish this and I'll give way to both the honourable members. Legal aid will no longer routinely be available in 13 areas, including most private family law cases, clinical negligence cases, non-discrimination employment cases, immigration cases, some debt and housing issues, some education cases, and welfare benefits cases. Give way to the honourable gentleman.
Thank the right honourable gentleman for giving way. How does he square what he's saying with what Baroness Hale of the Supreme Court has said, that this is actually a ludicrous bill, and that these provisions will disproportionately affect those most vulnerable in society, particularly ethnic and minority people?
Well, I'm going to have to. I've heard of Baroness Hale's opinion, and I also have very high regard for Baroness Hale, who's a very distinguished lawyer, and I shall have to study our opinions and perhaps even have a meeting with her and discuss it, because I'm surprised by her response. Where we have started from is making sure we did not damage access to justice for vulnerable people in matters of such importance that society as a whole would wish to make sure they were protected. And I do think either the Honourable Lady has misunderstood the effect of our proposals, or she's misunderstood why we are doing it. We just have to get back to spending an affordable amount of money on paying for things that the taxpayer should actually pay for. to defend the vulnerable. I mean, we all start as lawyers, let alone as citizens, with a slight bias in favour of legal aid because everybody's used to doing it. But the scale of legal aid is now expanded, its scope is too wide, and it needs to be reformed. I've got people behind me, I think.
I'm grateful for the Justice Secretary saying that legal aid will be available for defending the vulnerable. One area in where I declare an interest as a duty solicitor is in the police station. And I would invite my honourable friend to consult carefully about the practical implementation of proposals to limit legal aid for advice and assistance in police stations, given that his officials no doubt will bear the scars of previous implementations which have become bureaucratic nightmares and don't get the benefit, as one needs within the police station, of informed legal advice which can lead to an efficient justice.
Well, we will look at that and we'll consider it carefully as we go through. Now, what the bill does at the moment is replicate a provision which was taken from an earlier bill by the party opposite. And it appears to give a power to take away the right to legal aid. Yes, if you like. It appears to give a power to take away access to legal advice in a police station. Now, the last government legislated to do that, but never did it. We have no current intentions of doing it. So we will consider the issue, and no doubt if my honourable friend or others get the chance, we'll return to it at the committee stage of the bill. But I do realise that there's some concern. Now, I can't remember who's getting up first. So.
I'm very grateful to the Lord Chancellor. At the AGM of Liberty earlier this month, his honourable friend, the member for Halton Price and Howden, indicated that in his view the government should reconsider its plans to remove certain categories of social welfare law, at least for a period when government reforms elsewhere in the system, for example welfare reforms, would create an increased demand for advice. Will the Lord Chancellor take on board that excellent advice by his honourable friend and protect these categories of legal aid, at least during a transition period?
Well, we have consulted very carefully on the legal aid. I mean, we did on both parts, but we have made quite significant changes to what we originally proposed. But on welfare benefits, we are still of the opinion that the welfare system was not intended to provide a source of litigation where legal advice was required to take an appeal in the last resort to a tribunal, which was not intended to be a legalistic activity. You are actually trying to apply what my right honourable friend, the Secretary of State for Social Security, is trying to make more comprehensible, the rules of entitlement to social security in a sensible fashion. And I don't think it's a promising area for legal advice.
Most grateful to the Justice Secretary. I actually was present at Lady Hale's lecture. I wrote down what she said. Courts should be and are a last resort, but they should be a last resort which is accessible to all, rich and poor alike. That is what she said. Let me tell him now, my constituents are people who need advice on immigration, on welfare, on housing, whose very lives can be wrecked by the fact that they cannot get legal assistance. Where am I to send them? How are they to get justice with the provisions in his bill on legal aid and on no win, no fee?
Can I just remind the House how many people wish to contribute to the debate? And I think that the mission of discovery for us is to limit our interventions. Kenneth Clarke.
I've already said that access to justice is absolutely fundamental, but the fact is that the taxpayers' money cannot be used to give access to justice to large numbers of people in large areas of law where the ordinary citizen would not contemplate litigating, because the ordinary citizen on an ordinary income would not think they could afford embarking upon this. That's why what we've tried to do is identify, and we did consult very carefully. We concentrated on vulnerable people, and we concentrated in those areas of such importance that plainly society as a whole would feel there was a need for taxpayers to finance people of limited means, particularly the poor we're talking about, to give them access to justice. And I ask the Honourable Lady to judge all our proposals on that basis. Lady Hale seemed to think we were abolishing other access on the basis because people were using it too much. That is not the reason we have. But we do have a system 4 times as expensive, and that is New Zealand. And you do have to concentrate the mind and decide what it is justified taxpayer to pay for. And I'll follow your, I think, helpful steer, Mr. Deputy Speaker, and go on a little bit further. Otherwise, I do realise these are important matters, but I will find myself otherwise giving way to everybody who's in the chamber. As I already said, few of these are easy choices, but there are often disputes about financial issues rather than life and liberty, and it's sensible to give such things as financial disputes a lower relative priority. And it's sensible, too, to address areas that the public considers unreasonable. So, for example, we're cutting out legal aid for squatting. And following representations from the Judges' Council, we're ending legal aid from some repeat judicial reviews on immigration and asylum cases which have already had a hearing and where repeated review is just being used to obstruct and delay proceedings. Now, across some of these areas, reformed no-win, no-fee arrangements will be available. But our broader ambition is that people will be encouraged to use alternative, less adversarial means of resolving many of these important problems. For private family law cases, the government is actually increasing the spending on mediation and legal advice in support of mediation by 2/3, or £10 million to a total of £25 million each year, because mediation has quite a high rate of success, 70% or so, in resolving most of the family disputes that go before it. We've made no blanket funding exclusions. The bill establishes an exceptional funding scheme for exceptional cases administered by a statutory office holder free of ministerial control. This will provide funding for an excluded case where, in the particular circumstances, the failure to provide support will be likely to result in breach of the individual's right to legal aid under the Human Rights Act or European law. Now, let me just deal with this important point, because I've heard widespread concern, including from my honourable friend, the member for Loughborough, a few moments ago, about the future of not-for-profit advice centres. Now, I agree that they do very important work in providing quality, worthwhile advice of the kind required by very many people who shouldn't need adversarial lawyers. I have to point out that legal aid only represents one of several income streams for many organisations, with 85% of Citizens Advice Bureau funding coming from other sources, and half of all bureaus getting no legal aid funds at all. But this is an issue that needs to be considered and has been considered on a cross-government, interdepartmental basis. We are working with the sector and across government to ensure that the implementation of government reforms helps to improve the efficiency and effectiveness of advice services available to the public. We will be providing additional funding of up to £20 million in this financial year to help achieve this. And of course we are very mindful of the impact of reforms beyond this financial year, and will continue to consider the issues that this raises. Now, not at the moment. I'll go on a little further. In addition to the changes on scope of legal aid, the bill includes wider reform provisions, and some reform is urgently and obviously needed from what we inherited. I don't believe the public understands a system which can pay out millions of pounds from taxpayer-provided central funds to compensate acquitted companies and wealthy people for their legal costs, whether it's the £21 million paid to the firms in the Hatfield rail crash, the £18 million paid to a number of pharmaceutical firms accused of price fixing, or the hundreds of thousands of pounds that have on occasion gone to celebrities accused of affray, assault and other crimes. So Part 2 of the bill establishes that defendants who decline legal aid and pay privately in the higher criminal courts will no longer be able to recover the costs of an expensive private lawyer if acquitted. In the magistrates' courts, the sums recoverable will be limited to legal aid rates. Firms will be expected to insure against criminal prosecutions and will no longer be able to recover costs from the taxpayer. So this bill is about delivering reform across the justice system. We try to think about it in a joined-up way. Take problems often affecting women, for example, who Lady Hale was concerned about, I think, when she spoke the other day. For victims of crime, I have recently announced funding for 15 rape crisis centres on a more secure long-term basis than the past, and funding for 4 new centres. For women using the justice system, we are prioritising those cases where there is greatest risk of harm within our legal aid reforms, retaining it for cases involving domestic violence, child abuse and child abduction, and we broaden the range of evidence accepted. On private family law, the taxpayer is increasing funding mediation and legal advice in support of mediation. More broadly on family cases, Part 2 of the bill extends the powers for courts to require one part... Very important point this. The bill extends the powers for courts to require one party to pay towards the other's legal bills in some cases where resources aren't equal, where, for example, a couple have parted and the man remains very prosperous and the woman is almost penniless and is trying to seek some remedy. The court will have the power to require one party to pay towards the other's costs. And with public family law, the taxpayer will still be providing over £400 million on family legal aid. For female offenders in the criminal system, I don't have and have never proposed replacing short-term prison sentences with community sentences. However, if we can increase confidence that community sentences will be meaningfully punitive, I think they could make the justice system more sensible in some situations. For example, ensuring there are decent non-penal options for offenders who have caring responsibilities where being sent to prison would cause chaos for innocent children in their families. And we are, in fact, on the question of women prisoners and how to deal with women offenders, proceeding on a very similar basis to that pursued by the government that we have succeeded to. So, Mr. Speaker, my vision is of a legal system that's substantially reformed. In addition to implementing changes to legal aid and the Jackson proposals on no win, no fee, my department is also developing and supporting work to improve civil legal processes, criminal justice efficiency and family justice. It's a measure of the challenge before us that this bill, which is on any measure a huge leviathan of a piece of legislation, is only part of the overall reforms we need to deliver. The changes we're making are of course financially necessary, but at the same time they will make the system more sensible and more civilised. But I never shrink from robust debate about improvement to important and sensitive public services. Any changes in the criminal law have always excited a quite extraordinary level of controversy, and they always will. But if we get this right, the prize is a justice system that properly contributes to a safer, fairer society, a justice system that's user-friendly, that works, that doesn't deny access to justice, and has less daunting waste with costs under control. It's actually a major reforming bill that I would have liked to introduce 20 years ago if I had stayed long enough at the Home Office. I now have the opportunity and I commend it to the House. Yeah.